Well, thank you all. You've now moved us, and particularly Scott, onto advocates' meetings and conferences. And obviously, there are restrictions around those, particularly in two counsel cases. Obviously, in single counsel cases, advocates' meetings were ordered in advance by the court, and I mean ordered in advance by the court, can be claimed as an event. Obviously, conferences are restricted, and there's a limitation of 2 of those. But in the two counsel environment, advocates' meetings follow very much what was in the original public law outline, which was 2 advocates' meetings. So in the event that it goes straight to a final hearing, you can have 2 advocates' meetings. If it's a split hearing, then you can have 2 up to the fact-finding hearing, and then 2 between the fact-finding hearing and the welfare disposal hearing. Now, there can be circumstances in two counsel cases where that might adjust a little bit. A prime example would be if there was a fact-finding hearing followed by an appeal of the fact-finding hearing, which led to a rehearing of the fact-finding hearing. In that situation, it may be possible to come back to us to say, we would like an extra advocates meeting. There have been occasions where during the course of the case, and in particular where a main hearing has begun, but has had to be adjourned because something quite dramatic has occurred during the hearing, which has led to a substantial adjournment, and it might mean obtaining extra experts reports, where we might consider allowing extra advocate meeting in that scenario. But we are talking an extremely exceptional circumstance. In two counsel cases, the position is very much based around the fact that the model was priced in a way to provide reasonable remuneration over the life of the case. And single events should not be seen in isolation. It's the bottom line costs that are generated through the global number of events, which should reflect the reasonable remuneration for the whole of the case. And it's sometimes lost in some translations that event items are seen in isolation. But of course, they include not only the time spent at a particular event, which is a hearing, for example, but that also embodies preparation time in relation to that hearing, but it's preparation time for the whole life of the case that's built into that single event price. So any extra events that are sought distort the model that exists, and therefore can distort the overall events, the reasonableness of the costs in relation to the work to be undertaken over the life of the case. Chris, Scott, Rebecca, please come back in to have any pickup that I might have missed or that you want to add into there.
To be honest with you, Anthony, I completely agree with you on my two counsel hat on. Completely agree with you. It is 2 pre, 2 post fact finding. Also, be aware that even if the court has ordered further advocates meetings, again, doesn't mean that you're going to get more than 2 advocates meetings on 2 counsel cases. The guidance is very clear, and as you've said, it would have to be something exceptional even to warrant asking the question of having an additional advocates meeting. I'll be aware of that. I won't talk about single counsel because Scott will. There is a difference between how many advocates meetings you can claim for single counsel and you can for 2 counsel, and that's something I'll pass over to Scott, because obviously he would be a good place to discuss about that as well.
So I think the big difference is that you can claim as many as the court order in single counsel cases as you can in FAS. During the pandemic, obviously we've seen a massive rise in remote hearings, and advocates meetings have been a big part of that, and so there's probably been an increase in the number of advocates meetings. I've got no actual proof of that, just kind of a feel for what I see in the diary. But I think one of the things that you have to be aware of is that it can't be ordered retrospectively. You can't ask the judge to shove it in the order after it's taken place and then expect to claim it. The judge has to have ordered it beforehand. Now, that doesn't necessarily have to be in a formal court order. It can be the judge is in an email exchange between the advocates, and the judge says, yes, it would be a good idea to have an advocates meeting before the next PHR. Please, can you arrange it? That's good enough for the LAA. But what you can't do is just make that decision yourself between the advocates, then have it, and then have the judge put it into the order after the hearing's taken place. That wouldn't count, so that you wouldn't be able to claim that, and that's something you need to be aware of. And I think there's a common error which clerks make, and I can add myself to that list because I've done it very recently by mistake and then spotting my mistake afterwards, which is that you go from the single counsel VHCC, where you can claim as many advocates meetings as you like, and I had a case where I'd done 6 leading up to the fact-finding hearing. Just before the fact-finding hearing, it got slightly more complex. There was more disclosure from the local authority, and so we decided to get a QC to go with our junior counsel. Authority was granted, which then meant we had to go back and recalculate the fees. So 4 of those advocates meetings I could no longer claim for, because you can only claim 2. So it's one thing that counsels clerks can often fall foul of, and in the same way solicitors could have them in their case plans on a single counsel basis. When it then gets converted to 2 counsel, you can only claim 2, same as we can. So it's one of those things to keep an eye on when a case changes from single to 2 counsel.
I'll move on to experts' fees and disbursements now, if I may. We've touched on this already, really, in terms of the documentation needed in support of the final case plan, and really how important that is. This was really picking up on that. Those points have already been made. I'm not sure this needs extra elaboration, but one area I think needs to be important, needs to be expressed, is for experts' fees. If you're going to go over the codified rates within the regulations, or if you're going outside of guidance in relation to the number of hours that experts are doing, you do need a prior authority. So if that is the situation, go and get a prior authority. If it's within the codified rates and the expert's going to be within the guidelines in the amount of time they're going to be spending doing reading and providing the written report, then that's fine. Don't need the prior authority for that. But you do, if you're going to be outside either hours or the actual hourly rate. I'm going to move on. I don't know whether, Rebecca, have you got any observations you want to bring in around disbursements or experts' fees at all?
No, I would agree with you there, really. I would just second the idea of just stop and check and make sure that you're happy, refer to the guidance, and try and deal with it at an earlier point rather than waiting until the very end. It just slows things down, and it slows down you getting paid. Yeah,
super. I'm going to move on to counsel's fees. Again, we've talked a lot about counsel's fees, I know, but it's really more about making sure that the fee notes align with the actual events on the case. Scott and Chris have talked about that. They've talked about making sure that they see the case plan, so that if they've given you previous fee notes, but there may have been a change in case, as Scott certainly talked about, and the implications of changes in the way the case has developed can impact upon the fee notes you might have already been sent. So do check those. Don't get caught out, because, again, as they've explained, that can build in delays. If you've got an incorrect counsel note within either a fee note, or you've got it incorrectly stated in the case plan, that will cause a delay at the end of it. So it's a case of have that conversation with counsel, have that conversation with counsel's clerk, let them see the case plan that you've prepared, just to make sure that what the information they've previously provided to you, if nothing else, is correct. Scott, Chris, I don't know whether you want to come back in around that point at all, although I suspect that we've...
No, I'll second that. I've got nothing further to add on that. I think we've covered that quite clearly earlier on in the webinar, from my point anyway.
Yeah, I think the only thing I would say is that if thinking again about cost estimates, in the very early stages, if you're not 100% sure and you're not sure if it's going to exceed the 25,000 limit, it's always worth asking counsel's clerk for cost estimate both at fast rates and at events, so you can compare and contrast and make sure. It's something that we do sort of automatically at St Mary's. I'm sure Chris will do the same thing. It makes sure that you've got all the information that you have to make those decisions when the time comes.
Yeah, I agree, Scott. Even if I see a single council case that's exceeding 10+ days, I'll even just ping a little email into the solicitor saying, has it been registered as high cost? Do you need anything from me? I don't think that hurts. Just have a bit of communication, because as you say, especially with single council cases, they're not as clear as two council cases are.
Yeah, super. Rebecca, have you got any observations from the cost draftsman's perspective around council's fees at all that you feel is helpful?
I think what the gents have just said is brilliant, and it does make a really big difference to us. Having that information up front and having those two comparisons is incredibly helpful for cost draftsmen when they're considering the fees. And if there are any more council's clerks that are watching that can provide that as an additional service, it really does help. It helps us and it helps the providers.